let me tell you, I got a couple of informational advisements for you, sir. Ready?
Love it. Yep, let's hear it.
Mr. Augustine is just can't find his way to court this morning. He's refusing.
Okay.
And Mr. Day is on his way, but they had a little bit of a situation on his way out. He'll be here momentarily, but in order to, make it a little faster, can we just start with the misdemeanors?
Yes, please. I'm going to continue, Mr.
Oh, I'm sorry, sir. We're going to do the two Spanish first.
That's fine.
Just a sec. Because I have Alcaraz Rocha, but who's the second?
Marquez.
Marquez Dizar? All right.
Mr. Colesrude, fair warning, this might be a rough morning for the defense.
Understood.
Ma'am, your name, please.
Buenos días, señora. ¿Cuál es su nombre?
Mariana Elizabeth Alcaraz Rocha.
Mariana Elizabeth Alcaraz Rocha.
All right, Mr. Rocha, this is time for your initial appearance.
Señorita Rocha, es la hora fijada para su comparecencia inicial.
We're going to go over your charges as well as your conditions of release.
Vamos a hablar acerca de las acusaciones en su contra y las condiciones para salir en libertad.
First, understand that you have the right to remain silent and anything you say can be used against you.
Primeramente, entienda que tenga el derecho a guardar silencio. Todo lo que usted diga se puede usar en su contra.
You also have the right to an attorney. I'll be appointing the legal defender's office to represent you in these matters.
También tiene el derecho a contar con la ayuda de un abogado. Voy a nombrar a la oficina del defensor público para que lo defienda con respecto a estos asuntos.
Further, you have an attorney sitting next to you right now who's going to assist you in these proceedings.
Además, el día de hoy tiene sentado enseguida de usted a un abogado que le va a ayudar durante este procedimiento.
Ms. Rocha, I've reviewed the interim complaint by law enforcement, the pretrial services workup, and I'll hear arguments from both the state as well as your attorney.
Señorita Rocha, he leído la queja interina que escribió los agentes del orden público, he leído el informe que preparó la agencia previos al juicio y voy a escuchar los alegatos que presenten la fiscalía y su abogado.
Today, ma'am, I'm seeing you on one count of organized retail theft, one count of false reporting to law enforcement officers.
Hoy les voy a ver, señora, por un cargo que tiene en su contra por un robo organizado de tiendas y también por reportar falsamente a agentes del orden público.
Counsel, I have information that there's a probation violation warrant that she's being detained on a probation hold. My inclination was to hold her on a $5,000 cash secured bond. Does the other party wish to be heard?
One moment, please. One moment, please. One moment, please. Sí, tengo información de que actualmente usted ha incumplido con la libertad a prueba anteriormente puesta en su contra. Tengo aquí información de que tenía una orden de detención por respecto a este incumplimiento de la libertad a prueba. Entonces, lo que estoy pensando hacer, indica el juez, es dejarla en libertad, poner una fianza para si quiere salir en libertad de $5,000. Esta fianza puede ser en efectivo o garantizada. Y entonces el juez le pregunta a los abogados si alguien quiere decir algo.
No tengo, es que nadie sabe cómo se dice así.
Your Honor, I understand the court's position, especially given that there's probation hold. The thing that I would point out here is based on, what we're hearing, the circumstances alleged in the interim complaint. Mariana here is a very limited financial means. What I've learned here, have, any support from family here in town. She's been living on the street. So while I do agree that a nominal bond is important here so that she gets the credit and the back time that she may be earning while she's incarcerated, I would ask the court to impose a bond of $1,000, $1,500 under the circumstances. She has no prior felony convictions. I understand there's some misdemeanor history, though the PTS report doesn't go into detail as to what that may be.
One moment, please. One moment, please. Su señoría, quiero explicarle que la posición en que se encuentra la señorita Rocha, entiendo de que existe una orden de detención a causa de la libertad a prueba, pero yo también he leído la información con respecto a la queja interina y la señorita Mariana tiene poca ayuda familiar y estaba viviendo en las calles, no tenía apoyo de familia. Y entiendo que una fianza de mínima, una cantidad mínima, es importante para poder que empiecen a crear crédito por el tiempo que ha estado detenido, para que empiece a contar ese tiempo. Entonces yo estoy pidiendo, dice su abogado enseguida de usted, que le den una fianza de $1,000 o $1,500. La señorita no tiene ningún tipo de antecedentes de felonías o delitos penales graves. Entiendo de que sí existen delitos menores, pero el informe que te presenta con respecto a esto no indica con detalle. Okay, the interpreter of the part that she has misdemeanors, but the report does not specify in detail. That's the last thing I interpreted.
Yes, and so for these reasons, Judge, and given the fact that she's a mother, we're asking that you impose a nominal bond to the amount of $1,000, such that she may have the opportunity at some later point to address that or post that bond.
Entonces, por esa razón, su señoría, y de hecho también de que ella es mamá, estamos solicitando de que usted ponga una fianza de pequeña, mínima, de $1,000 para darle una oportunidad a ella, de ojalá que pueda entonces encargarse de esas cosas, pagar la fianza y salir en libertad.
Ma'am, I'll reduce my initial inclination and set the bond at 2,500 cash or secured with an order not to return to the incident location if you do post bond to the future date.
Muy bien, señora, entonces voy a cambiar lo que tenía pensado hacer. Voy a reducir la fianza suya a $2,500 en efectivo o garantizado. Tiene usted la condición de que si paga esa fianza no puede regresar al lugar donde sucedió este incidente.
Your next court date is January 20th at 1:30 p.m. That's your preliminary hearing. It is unlikely to go.
Tu próxima audiencia en la corte va a ser el 20 de enero a la 1:30 de la tarde. Esta es una audiencia preliminar. Es muy probable que esa audiencia no se lleve a cabo en esa fecha.
Please talk to your attorney about why it's at that court date.
Por favor, hable con su abogado con respecto a la fecha de esa corte.
All right, you're excused, ma'am. Thank you.
Señora, ya se puede retirar. Terminamos con su caso. Gracias.
Real quick, Judge, are there misdemeanor dates or is it just the felony date?
I only have a felony date, Mr. Coulter.
Okay, understood.
Su abogado preguntó rápidamente que si tiene una fecha para las cortes que tienen los delitos menores. El juez indicó que no. Lo único que tiene es una fecha para su felonía o delito grave. Gracias.
¿Qué? ¿Vas a decir? Señor, ¿te vas a bajar?
Your name, please, sir?
¿Cuál es su nombre, señor?
Miguel Ángel Márquez Guizar.
Miguel Ángel Márquez Guizar.
All right, sir, you're here on your initial appearance on charges of, give me 1 second. 2 counts of possession of a narcotic drug for sale, 1 count of possession of a narcotic drug for transportation, using an electronic communication device during a drug transaction. Z, you tell me when you want me to stop.
Okay, right there is good, Your Honor. Buenos días, señor. Está aquí para una comparecencia inicial. Deme un segundo. Está aquí unos cargos, unas acusaciones en su corte. Tiene usted 2 cargos ahorita en su corte. Uno de posesión de estupefacientes destinados para venta y uno también es por tráfico de estupefacientes y también por el uso de medios electrónicos durante una transacción de drogas.
I also have 9 counts of possession of a narcotic drug, 1 count, another count of possession of a weapon in drug offense, a count of possessing a weapon by a prohibited possessor, 2 counts of resisting arrest, and 1 count of possession of paraphernalia.
También tengo 9 cargos en su contra con respecto a tráfico de drogas. También en posesión de una arma durante un delito con respecto a drogas. También I'm sorry, Your Honor, after the weapons for the drug offense, what was the next charge after that?
Possession of a weapon by a prohibited possessor, resisting arrest, and possession of paraphernalia.
Thank you. También por poseer una arma después de haber tenido prohibido la tenencia de armas. También tiene usted por bienes parafernales y también por resistir el arresto.
You have the right to remain silent. Anything you say can't be used against you. You have the right to an attorney. I'm going to appoint the public defender's office to represent you, and you have an attorney sitting next to you to assist you today.
Tiene usted el derecho a guardar silencio. Todo lo que usted diga se puede usar en su contra. Tiene derecho a tener un abogado para que lo representen. Voy a nombrar a la oficina del defensor público para que lo represente a usted. El día de hoy tiene un abogado que está sentado enseguida de usted para ayudarle con el procedimiento el día de hoy.
The state, sir, is asking for a $25,000 bond. I'm surprised at how low that bond request is, quite frankly.
La fiscalía está solicitando una fianza de $25,000 en su contra. A mí de veras me sorprende mucho qué tan baja esa fianza es, indica el juez.
Your Honor, upon further review and in light of the court's position, the state would note not only the volumes and the trafficking and the sales, but this individual apparently admitted to not being in this country legally, and therefore we're looking at a raised flight risk, $100,000.
Muy bien, su señoría, indica el fiscal. Después de revisar la información y después de tomar en cuenta su postura, la fiscalía entonces indica que a causa de la cantidad tan grande del tráfico y de las ventas, de que esta persona admitió no estar en Estados Unidos o en este país legalmente y por esa razón se encuentra a estar a riesgo a darse la fuga, solicitamos entonces que la fianza sea de $100,000.
And Mr. Colesrud, so my initial inclination was a $50,000 cash bond. I recognize how high that is. I've got concerns with the amount of fentanyl. As you know, we've been doing this for a long time. That's a lot of fentanyl. The fact that Mr. Marquez Guizar indicated he lives in Mexico, I recognize. I'll let you go, Z.
Thank you. Abogado, le estoy indicando que yo estaba pensando solicitar una fianza de $50,000 en efectivo o garantizado. A mí me preocupó mucho la cantidad tan grande de fentanil que tenía, y nosotros ya estamos haciendo esto por mucho tiempo, y esta es una cantidad bastante grande, y el hecho también de que usted está residiendo en México.
So my inclination was initially $50,000 cash, but I'd like to hear from you, Mr. Colesrud.
Entonces, inicialmente estaba yo considerando una fianza de $50,000 en efectivo. Ahora vamos a escuchar lo que tiene que decir su abogado defensor.
So, Your Honor, I certainly understand the position the court's in, and I recognize the severity of the charges, the quantities alleged, the circumstances. I can understand all that. My concern here, Judge, is that there seems to be some sort of breakdown in what pretrial services is reporting for Mr. Marquez-Guizar's circumstances, and then what is alleged by the state in the recommendation. I will note that according to pretrial, Mr. Marquez-Guizar's had no felony convictions, no misdemeanor convictions, no failures to appear, no history of violence. This is a young man facing very serious charges, but they are the first charges that evidently he's faced. So I'm concerned there that the recommendation that's been filed that says he has prior felonies, a substantial misdemeanor record, a history of violent or assaultive behavior, none of that appears to be accurate. And then as it relates to his living circumstances, I'm sorry.
One moment, please. Ok, su abogado en defensor indica que entiende la posición de su señoría. Lo que pasa que él reconoce también que estos cargos son bastante graves, tomando en cuenta la cantidad que se presume que traía usted, que poseía en ese entonces, y las circunstancias. También toman en cuenta, pero la información como está escrita, como escribe el informe previos al juicio, indica que el señor Márquez-Guizar no tiene ningún récord, y también indica que la información indica que no tiene de récord ni de felonías o delitos graves, ni delitos menores, ni siquiera nunca ha faltado a alguna corte, no ha tenido ningún tipo de cargos violentos con respecto, y la información que indica también la fiscalía es distinta. Entonces a él, su abogado indica que el señor Márquez-Guizar es un hombre joven que no tiene antecedentes, y tomando estas circunstancias es la primera vez que sucede, pero la información que indica otra persona es totalmente opuesto. Otro agente, otro departamento está indicando que usted sí tiene un historial bastante grave, que tiene muchas felonías, que tiene muchos delitos menores, que tiene cargos por violentos por agresión. Entonces, okay, the last thing I said was the other one indicates that he has a lot of felonies, a lot of misdemeanors, and a lot of violent charges against him. That's the last thing I interpret.
Yes, and the last thing I know with the recommendation is that there's an allegation that there's a history of failing to appear for court hearings, and that's also not borne out by the pretrial services report here. I'll pause there for a moment.
Thank you. Esta otra cosa también que indica es que si usted también tiene otro récord previo donde no se presentó en la corte 4 veces, y esta información no está incluida en el informe de servicios previos al juicio.
And
Your
so
Oh.
the last thing I would note, Judge, is that pretrial services noted that he has been a resident of Tucson for some time, a number of years. And so as it relates to, a potential for failure to appear, Mr. Marquez-Guizar resides in Tucson, and I have no reason to believe that would change if he was in some form or fashion able to post a bond. So I would ask the court instead to go with the state's initial recommendation in light of his lack of history, lack of failures to appear, lack of violent, convictions or criminal cases in the past, and his living circumstances. Thank you.
Your
Entonces,
Honor,
one moment, please. Lo último que quiero indicar, su señoría, entonces que el reporte que indica la agencia previos al juicio, ahí indicaron que usted no tiene un récord de que nunca ha faltado algún tipo de corte, que ha estado residiendo aquí en Tucson por unos cuantos años, que el señor Márquez-Guizar probablemente no va a cambiar esa situación con respecto al hecho de que vive aquí en Tucson y que sí se va a presentar en la corte. Entonces, lo que está solicitando su abogado es que le imponga la fianza inicial que había puesto la fiscalía, ya que dado el hecho de que no tiene historial de antecedentes penales, no tiene historial de haber faltado a la corte, si no tiene ningún tipo de delito violento. Y eso es todo lo que tiene que solicitar su abogado.
All right, Neil, let me be heard, and then I'll ask if you have any further comment, okay?
very well.
So, Mr. Colesworth, I understand your positions. I was not using many of the factors you indicated against Mr. Marquez-Guizar, or for him for that matter. My initial inclination of a $50,000 cash bond was solely based on the charges and Mr. Marquez-Guizar's immigration status, which is in question.
¿Ok? El juez le pidió al abogado de la fiscalía que esperara un momentito, ahorita le va a preguntar su opinión. Lo que quiere indicar a su abogado es que lo que el juez tomó en cuenta para tomar su decisión con respecto a la fianza fueron los factores que estuvieron incluidos del señor Márquez Guizar. Fue la razón por la cual el juez está solicitando una fianza de $50,000 en efectivo. Únicamente está basándose en los cargos en su contra y el hecho de que la situación con respecto a migración del señor Márquez Guizar ahorita es dudosa, no se desconoce.
I've got a lot of curiosity about this case and the fact patterns here, but my inclination is still to hold Mr. Marquez Guizar on that $50,000 cash bond. Neil, did you want to be heard further?
One
Your
moment,
Honor,
please.
it's comfortable.
One moment, please.
Sorry.
Thank you. Tengo mucha curiosidad con respecto a este caso, indica el juez, y los patrones que se observan con respecto a este caso. Entonces, lo que yo tengo pensado es ordenar que que se quede una fianza de $50,000 en efectivos para el señor Márquez Guizar.
Okay, Neil, go ahead.
Your Honor, this individual may reside here in Arizona, may have done so for quite some time, but by his own admission, that has been illegal ab initio. The flight risk cannot be overstated here. If he were to post a bond, he could easily go past, I know that Pima County isn't cooperating with ICE anymore, but all this individual needs to do is disappear south of the border and we will likely never see him again. And that is not in the interest of justice because as the court did note, this is a substantial amount of drugs.
Okay, one moment, please. Ok, esta persona, este es el fiscal ahora, el fiscal está indicando, esta persona dice que probablemente ha estado viviendo aquí en Arizona, probablemente por una cantidad de tiempo, pero por su propia admisión indicó que ha estado quedándose aquí, si es que se ha estado quedando aquí de una manera ilegal. Entonces, esto posa entonces que usted pues un riesgo de darse a la fuga si paga la fianza y se lo dejan salir. Entonces, esta fianza... Bueno, ella se da cuenta, el fiscal, que el condado de Pima ahora ya no está cooperando con la agencia de ICE, con la agencia de migración y el de aduanas. Entonces, lo que él indica, es que usted si paga la fianza, lo que tiene miedo es que se va a dar a la fuga, se va a ir a cruzar la frontera hacia el sur y ya nunca lo vamos a volver a ver. Entonces, esto es en contra del interés de la justicia, indica el fiscal.
All right, court's initial inclination stands. Marquez Guizar, you're excused.
Bueno, dice el juez, entonces mi inclinación previa se mantiene firme. Señor Márquez Guizar, ya se puede retirar.
What was the next court date, Judge?
January 20th, Eric.
Thank you.
La próxima audiencia es para el 20 de enero. Your Honor, may the interpreter be excused?
Yeah, thank you.
Thank you, Your Honor. Interpreter is disconnected.
Person. And we get ready.
Your name, please, sir?
Shane Paul Joseph.
Thank you. All right, Mr. Joseph. I'm seeing you on a Tucson City Court case for criminal trespass in the 3rd degree. I'm going to consolidate this case, CM 260000752, with CM 250293111, CM 250293323, and vacate the court date on January 28th at 10 a.m. I'm going to hold you on a $1,000 cash bond, set a court date for January 14th, in front of Judge Maldonado at 1:30 PM. And appoint the city PD to represent you, sir. If you do post bond, you can have no contact with Sheriff Joseph and you cannot go to 1602 North Dodge Boulevard. And enter pleas of not guilty on your behalf, sir. If you fail to appear at the next hearing, a warrant could issue for your arrest. Trial can go forward in your absence. If you're convicted at trial, don't appear for sentencing within 90 days, you can lose your right to appeal. Hold on, sir. Sorry, sir. Let me change that court to Eric. It's actually January 16th, not the 14th.
The 16th, understood.
All right. Thank you, sir.
Thank you. Hayes. All the way out, Joseph, or left hand side, sir?
Your name, please, sir.
Eric Mays.
All right, Mr. Mays, this is the time for your initial appearance on city court charges for disorderly conduct and criminal trespass in the 3rd degree. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. I will not be appointing an attorney on this occasion. You can certainly ask Judge Cranshaw to do so. I'm going to release you, sir, on your promise to appear at your future court dates. Your next court date is going to be February 10th at 1:30 PM. No contact with Andrea Bonda. Understood?
Yes.
Will that be a problem?
No, sir.
All right, sir. No contact with Andrea Bonda. Go to court on February 10th. If you do not go to court, a warrant could issue for your arrest. Trial can go forward in your absence. If you don't appear if you're convicted and don't appear for sentencing within 90 days, you can lose your right to appeal, okay? The court's going to enter pleas of not guilty on your behalf, sir. You're excused.
Rubio, all the way out, sir, your left.
All the way up.
Your name, please.
Sergio Rubio.
Mr. Rubio, I'm seeing you on some city court charges for resisting arrest, disorderly conduct, criminal trespass, obstruction, and paraphernalia. These are failure to appear charges or failure to appear instances. I understand you're here on a Superior Court probation hold as well.
Yes.
So this is time for your initial appearance. What I'm going to do, sir, is release you on the city court case. Here's why. I'm going to appoint the city PD's office to represent you. I'm going to set a non-transport review hearing for February 3rd at 9:30 in front of Judge Bond. City court, the city PD will monitor your felony cases. If you happen to go to DOC, unfortunately, they will try to get the city to dismiss these city court cases. All right, sir. If you do not go to DOC, you'll hear from the city PD's office and you'll deal with the city court charges. All right, sir. All right, sir. Manager, please, if not guilty on your behalf for what it's worth, and your excuse, sir.
On city. Yeah, just the city. That's the only one he calls.
That's all I have then.
Okay. You get all right. How's buffering?
Larissa, are you for trial?
Yes, I am.
Anything for Martin Anthony Urias? Am I just missing it?
He's MPV. We did it.
Sorry, I can't see why. I thought we were on felonies already. We're not. These are last misdemeanors. My mistake. Huh? Marco Rios, I have him as a misdemeanor. Misdemeanor and a city, I've got JP misdemeanor and city court misdemeanor. Okay.
Sure.
Sit down now. I'm chill. That's not. That's not what they're taking.
Your name, please, sir?
Yes.
All right, Mr. Rios, I'm seeing you on a couple of different matters. I'm seeing you on a justice court case for assault. I'm also seeing you on some city court cases. The city court cases are failure to appear for disorderly conduct, criminal trespass, and then new charges of criminal trespass and resisting arrest.
That.
So this is your initial appearance. We're going to go over your conditions of release. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. I will be appointing 2 different attorneys for you in these matters. On the justice court matter, sir, I'm going to hold you on a $500 cash secured bond and appoint Alexander Ball to represent you. He can help you out on the new assault charge. All right, sir? You'll have court on January 8th in front of Judge Garza. That's in justice.
So.
It's going to be your arraignment, sir. And it'll be the new assault charge. Yes, sir.
Don't charge of assault anywhere. That never assaulted anything.
All right. So speak
That times.
to Mr. Ball about that. All right, sir?
We're not talking to Mr. Forgotten times.
Well,
That's not what I did.
a misdemeanor assault can still be an assault. And
You're talking about a child. You're talking goddamn. I can do that.
well, speak to Mr. Ball about that. Okay?
Fuck what you goddamn. I don't give a fuck about the way you got to put pretend or that shit. Fuck this whole system. Fuck you, that judge, and the fucking goddamn assault. I didn't assault anybody. That's all I'm saying.
Mr. Rios,
Charging me with assault, misdemeanor assault, you're titling it wrong. I didn't assault anybody, motherfucker.
Mr. Rios,
That's all I'm saying.
Mr. Rios, I'm also going to appoint the city to help you out on the city court cases.
Help yourself to my goddamn. I ain't paying a fine or a fucking fee. I don't know what you want.
I'm going to assign this case to Judge Blue. He's the mental health court judge. I'm going to set a video review hearing for January 15th at 1:45 p.m. Hold you on a $500 bond on that case as well. All right, sir. Now you're excused. That was an assault. I don't miss sitting there. Yeah. Thank you.
I'm going to.
Your name, please, sir.
Gianangelo Salvato.
All right, Mr. Salvato, this is time for your initial appearance. We're gonna go over your charges as well as your conditions of release. First, know that you have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. I'll be appointing the public defender's office to represent you. You also have an attorney sitting next to you right now to assist you in these proceedings. I'm currently seeing you on one device.
Yeah, so. Sorry.
Talk to your attorney first, sir, okay?
Yes, sir, of course.
All right. So
So with that, I'm Eaglemont.
All righty, Judge, I think we're ready.
all right.
You're
Neil,
out of place.
you back for no bond hold. He was on release. I don't have information he was on release. Do you have a case number for that?
One moment, Your Honor.
Yeah,
Don't say anything, Mr. Salvato, okay?
One moment. Your Honor, let me pull up the narrative and I will be able to cast some light on this. One moment. Yes, moment, Judge. Your Honor, the state would take it back. He was on probation wearing an ankle monitor. I do apologize for the oversight. Given Mr. Salvato's history, given all of the facts, the state would modify its recommendation to $15,000.
All right. So I understand the state's concerns. I understand the serious nature of what Mr. Salvato is alleged to do. My inclination was actually to release Mr. Salvato to pretrial services, given his age, given the fact that his mother's indicated he can be with her, given the jail's alleging or insinuating at least that there might be a mental health aspect to his case and he might benefit from treatment on the outside. So defense, do you have anything to add?
Nothing further to that, Your Honor.
Mr. Salvato, do you understand that you can go home to your mom?
I understand that and I appreciate it very much.
Okay. Is that what you want to do, sir? Do you want to go home to your mom's house?
Yes, that's what I could do.
I understand you might have been homeless for a couple of days here. Is that right?
Yeah, it was just you can't really call it homeless if it's just a couple of days, you know.
All right, man. So go back to
Yeah.
your mom's house. I'm going to appoint the PD's office to represent you. You've got court on January 27th, sir. All right. Because of the allegation that you were trying to remove a ankle monitor. Don't say anything further. All right. Talk to your attorney. That court date's not going to go, but talk to your attorney about the next steps in your case. All right, sir.
All
All right, sir. You're excused.
Thank you, Judge.
Which ones? Yeah.
Right.
All we're really conversing. That order, in order to student, there you go. Here.
Are we bringing in all the felonies jail?
Solo sumisos.
So, this kind of.
Sí.
All but one,
And
we got a couple of these, so not.
Your Honor, not all of them, but we got both of them in here.
All right.
First, order, the first time in chair.
Right here, get it.
Your name, please, sir?
Anthony Astorga.
Mr. Dorga, we're going to go over a handful of matters with you, but all the other individuals who are pending court this morning are behind you. All right, this information is for Mr. Astorga, as well as the rest of you ladies and gentlemen who are here for court this morning. This is your initial appearance. We're going to go over your charges as well as your conditions of release. First, you have the right to remain silent. Anything you say can be used against you. The right to an attorney. If you're here in a felony case, I'll be appointing an attorney next to you. Further, if you're here in a felony case, you have an attorney sitting right next to you. So before you speak, make sure you speak to Mr. Colesroot. This is just the time for your initial appearance. So it's only to set conditions of release and a future court date. Mr. Astorga, can you please state your name?
Astorga.
All right, Mr. Astorga, I have you on CR 20252680. This is a Superior Court case for trafficking stolen property, possession of a narcotic drug, possession of paraphernalia. I also have you on 3 city court cases for failure to appear, on possession of paraphernalia charges. The state's asking for a $2,000 bond. That was the warrant amount. That was my inclination. Mr. Colesroot, do you want to be heard?
Briefly, Your Honor, I'm looking through. I don't believe that I received a copy of the complaint in this matter. But I will say here.
There wasn't one, Mr. Colesroot, because of the warrant. It was a warrant case. It was a grand jury warrant.
Grand jury warrant. Okay. The thing I did see this, and the thing that kind of concerned me, Judge, here is that the procedural posture of the case. So it appears Mr. Astorga was initially charged, looks like back in March, and then the case was dismissed. 4 months later, the state went through the grand jury to indict Mr. Astorga, and it looks as though the summons was mailed general delivery. So I don't have any idea how Mr. Astorga was supposed to have known that he had been indicted on this direct indictment, seeing as the case had been dismissed, and he wouldn't be in a position to know that the case was to be refiled, that the state intended to do that and had in fact done so. So I understand then, that there's a warrant, that he was picked up on that it's been some time since that warrant issued and the case had been indicted. But the fact of the matter is that Mr. Astorga wouldn't have had notice of that indictment being filed. So I'd actually ask, Judge, that you release him to pretrial services, give him an opportunity to remain in the community, participate in his case, and assist in his defense from within the community rather than here in jail, just as he would have had he received the summons, shown up at his arraignment, and participated in this case in the manner in which it normally goes.
All right, so Mr. Astorga, I would do that, but for the fact that there's 3 failure to appears for city court matters as well. Here's what I'm going to do. I'm going to set the $2,000 bond cash secured that was mentioned in the warrant. I'm going to set an arraignment of January 14th at 1:30 p.m. Because I'm holding you on that felony case, sir, I'm going to set a non-transport review date on your city court case. I'm going to set this in front of Judge Klotz. I'm going to appoint the city PD to represent you on your city court matters. Set a non-transport review hearing for February 13th at 9 a.m., sir. You will not go to that hearing, sir, but the city PD will advocate for you at that time.
And Judge, who's appointed on the felony matter?
PD, Eric. Your name, please, ma'am.
Mary Beth Cox.
All right, Ms. Cox, I have you here on one count of possession of drug paraphernalia, one count of possession of narcotic drug. State asking that you be released to pretrial services. I am inclined to do that. Have you heard of the STEPS program, ma'am?
Yeah, I have actually.
Right. Is drug treatment something you're interested in doing?
Yes.
Right. I'm gonna set a STEPS screening for January 14th. Eric, do you waive time for the PH?
Yes, Your Honor.
Right, so what that means, ma'am, if I can find the PH date. All right, you'll have a preliminary hearing scheduled for February 23rd. That is highly unlikely to go. However, you do have to go to the STEPS screening if you have any interest in doing the STEPS program, whereby if you do your drug counseling and drug treatment, the state will dismiss these charges. If you don't go to that screening, this will very likely just be a class 4 felony case. Understood?
Yes.
All right. I'm going to appoint the PD's office to represent you, ma'am. And that concludes this matter, ma'am.
The reason.
Yep, so when you get a call back, first thing you do, we're gonna call about defendants and be there. Yes.
Okay. Thank you. Thank you, sir.
I'd like to throw a button for PTS. I did, right? Okay. Huh? Yeah, he said time waive, yeah.
I just figured I'd also say that. Yeah. Thank you. Oh, yeah. I'll go there.
You know.
Thank you.
Mr. Elam. Let's see the reps.
Your name, please, sir.
And Kosi Elam.
All right, Mr. Elam, I'm seeing you on one count of aggravated assault with a deadly weapon, one count of aggravated assault causing serious physical injury. You should know that your mother is present in the courtroom, sir, on your behalf. The state's asking for a $100,000 bond plus pretrial release. My inclination, Mr. Colesford, was to hold Mr. Elam on a $50,000 bond, given the serious nature of the charges to the alleged victim in this case with no contact order. Do you want to be heard, sir?
I do, Your Honor. No objection to the no contact order. I understand the reason for that. And of course, the circumstances here being what they are, the severity of the case. That being said, Mr. Elam here is a young man. He's 18 years old. There's felonies, no prior misdemeanors in his history, no prior history of violence. You know, I can only speculate at the circumstances alleged in the interim complaint. And he's got a place to live here in town.
Mr. Elam, let Mr. Colesford speak and then speak to your attorney. And then if Mr. Colesford thinks it's wise, he'll let you speak.
So he's got family support, obviously, here today on his behalf. His father has also indicated he's got a place to stay. And it doesn't appear that that's where his cousin lives. So, you know, as it relates to, you know, a flight risk, I don't think we're looking at that here today. And as it relates to a continued threat to the alleged victim, I understand, you know, the state's position on that. But the fact of the matter is here, so long as they live apart and there aren't instances where they're going to come into contact, I think that the court can be assured that there isn't going to be a future threat of harm, especially if the court is to order that they have no contact. As to the dollar amount, Judge, the thing I would point out here is we're talking about a young man who's unemployed, who's recently, 18. The rules of criminal procedure under 7.3 obligate the court to take into consideration a person's financial circumstances if the court is going to impose a monetary bond. If you're going to do that, Judge, it's got to be the least onerous condition in the absolute lowest amount possible to ensure that the court's concerns are addressed. And imposing a $50,000 bond is going to be far above and beyond what Mr. Elam here is going to be able to afford himself or likely for his family to post to secure his release. The rules indicate that a monetary bond should not be imposed if it's going to result in unnecessary pretrial incarceration solely based on the person's inability to pay. And that's exactly what's going to happen here, Judge. So I'd ask that you release Mr. Elam to the care and custody of his family under the supervision of pretrial services. If you're going to impose a bond, Judge, I ask that you do it in as the rules demand, the least onerous condition, the lowest amount possible, such that Mr. Elam might be in a position to actually afford to secure his release. Thank you.
Your Honor,
Yes.
the state's only asking for a $100,000 bond because it doesn't say whether or not this person is the victim is alive or dead. If we knew the person was looking at potentially fatal injuries or was in the ICU on life support, we would be asking for $750,000 or $1 million, which is honestly, and to be very glib about it, the going rate for a murder charge. Your Honor, this is a person who's attacked somebody with what looks like a pair of scissors. This is a danger to society. He is 18. He is entitled to all the responsibilities of adulthood. Rule 7.3 is not being run afoul of at this point by a $100,000 demand. This looks to be unprovoked. This looks to be absolutely wanton. And this person has demonstrated that they are a danger to people that apparently just offend him in the slightest. That is absolutely dangerous. That is absolutely a situation where a high bond is entirely appropriate.
All right, counsel, I'm going to hold Mr. Elam on that $50,000 bond. Not necessarily because I believe Mr. Elam's a risk to flee, but because I do believe there's a further risk to the community and to protect the victim in this case. If factors change, Mr. Elam, your attorney certainly knows how to advocate for you at a future bond hearing. If I haven't said so already, I'll be appointing the public defender's office to represent you, sir, and I'll set that preliminary hearing date of January 20th at 1:30 p.m. That date is unlikely to go, sir, so please speak to your attorney about why I've set that court date. All right, sir, your excuse. Thank you. Hi there. Your name, please, sir.
Arthur Joseph Escobar.
Mr. Escobar, give me 1 second to pull up your file for pretrial. All right, Mr. Escobar, I'm seeing you on a number of different matters here. I've got some felony matters for possession of a dangerous drug, possession of a narcotic drug, paraphernalia, and I've got a misdemeanor criminal damage case. I've got 2 counts of disorderly conduct. I've got a failure to appear for a case out of Marana and a failure to appear for a case out of Pima County Justice Court as well. Let's start with the felony case, sir. On the felony case, sir, the state's asking for pretrial service release.
Okay.
It's a generous ask. And I will absolutely do that, sir. Have you heard of the STEPS program, sir?
Yes.
Right. Are you interested in doing the steps program?
Yes.
I'm going to set a steps hearing, a steps screening on January 14th at 9 a.m.
Okay.
Council, you waive time for the PH?
Yes, Your Honor.
So, Mr. Esquivel, we're going to set a preliminary hearing on February 23rd. That court is unlikely to go. However, you have to go to that steps screening if you want to be considered for steps court. Understand?
On February 23rd?
That's going to be on January 14th.
Oh, on the 14th. Okay.
If you don't go to that screening, 9 a.m. on the 14th, you will not be considered for steps court. And this case will be treated as a class 4 felony.
I'll be there.
I'm going to release you to pretrial services, give them a call, do whatever monitoring they ask you to do. It will not impinge or impede with steps court. Understood?
Okay.
Your Honor, is the PD's office appointed here?
It is, Eric. Thank you.
Yep.
All right, sir. So that does it for your felony case.
Okay.
On your Miranda case, sir, I'm going to release you on your promise to appear. I'm going to give you another court date. Now you've got court in Miranda. I wish this didn't have to be this way, but it does. You've also got court on February 4th at 10 a.m. in Miranda.
Okay.
All right, so you've got to go there. Otherwise, there's going to be another warrant out for your arrest. And next time you see a police officer, they're going to arrest you. Understood?
Okay. Yeah, my biggest problem is transportation down there. I don't know
I
if
know.
the Sunshine goes that way, but
Probably
I
not.
don't know.
So at the very least, sir, at the very least, call the courthouse.
Okay.
All right, at the very, very least, just call the courthouse.
Okay.
The number's going to be in the paperwork we give you. On the justice court case, sir, I'm also going to release you. You'll have another court date. I wish you didn't have to have 3 different court dates in 3 different courthouses, but you do. This court's going to be on January 20th with Judge Foster at 1 p.m. Sorry, at 9:30 a.m. Wherever they're alleging you shoplift from, you can't go back there. Okay?
Okay.
So 3 court dates, 3 courthouses. Quite frankly, the most important one right now is the court date on January 14th for your step screening.
Correct.
If you forget other court dates, talk to your attorney. All right, your felony attorney. At the very least, they'll know how to find these court dates in the system. But you've got to start going to court, man. All right, you're excused.
Thank you, sir. Thanks.
Oh, hold on, Eric. He's got a city court case too.
Oh. It's a grand slam.
That is a grand slam. All right. Sir, you've got a city court case for criminal damage and disorderly conduct. Give me 1 second.
I was never cited for that.
Well,
I don't know how that could even.
you're being charged with it, so cited for it at the time or not, you're being charged with it now by the city attorney's office. All right. Are you living at 4545 South Mission?
Yes, I am. Yeah, that's my mother's house, and my girlfriend and I.
Don't say anything else. You guys, do you have anywhere else to live besides with your mom?
No, I take care of my mom. She's elderly.
All right. I can allow you to go back to your mom's house. I cannot allow you to have contact with your girlfriend right now.
We don't have any more contact.
Okay.
It's done.
All right. So no contact with the alleged victim in this case, that being your girlfriend. I'm going to assign this case to Judge Million. Set a court date of February 10th at 1:30 p.m. in Tucson City Court. Eric, you got all those court dates down?
I do. We've got the 14th, the 10th in City Court, January 20th in Justice Court, and then February 4th for Marana City Court.
All right, sir, why don't you keep that piece of paper that Eric's going to give you? That's going to be the easiest place to see all your court dates there, okay?
Thank you.
All right, good luck, sir.
Thank you.
You're up, sir. Oh, we have part of the voice.
Sorry. Are you safe? It's okay.
Your name, please, ma'am?
Virginia Gallardo.
All right, Miss Gallardo. Gallardo or Gallardo?
Gallardo.
Okay.
Thank you.
Yeah. Ms. Gallardo, I'm seeing you on one count of burglary in the 3rd degree.
Okay.
State's asking for a $3,500 bond. Give me 1 second.
I'm sorry, Judge. So I understand the state's recommendation being $3,500 with pretrial. Were you waiting on?
I was rereading. Sorry, Eric. I was rereading the
I'm sorry.
complaint. No, you're fine. Ms. Gallardo, my inclination was actually to hold you on a $2,500 bond, given the allegations that SWAT had to come to the home to remove you. I see that as a risk to reoffend and a risk to not come to court. So that's my current inclination, Mr. Coulter.
So on that note, Your Honor, I'd ask that you release Ms. Gallardo to pretrial services. Issue being, I understand the court's concern with the, whatever the arrest incident may or may not have been. I will note that according to pretrial, she's got no previous felony convictions, no convictions for anything involving violence, no failures to appear in the last 2 years. And having spoken with Ms. Gallardo, she has another place to go to, a different daughter's residence here in town who is not involved in this case, not named in the complaint anywhere. So she's got a place to go to. We don't have history here, at the very least recently, to indicate that she would be an issue with a failure to appear. And if the court orders her to have no contact with the folks mentioned in the complaint, I'm sure that Ms. Gallardo would be able to abide by that order. The situation here being as they are, I don't know that $2,500 would be an amount that Ms. Gallardo would be able to actually afford to secure her release. And so taking her financial considerations into account, Judge, I'm asking that you release her to pretrial.
Ms. Gallardo, you have another daughter you're saying you can live with?
Yes.
Pretrials indicated that you were homeless at the time. Why weren't you living with her before?
Because I have one daughter that is in the complaint. I was been staying with her.
Right. And if I release you, you'll have no contact with Alexis and Jordan,
No contact at all.
at least for the time being?
I'm sorry?
At least for the time being, no contact?
At all, yeah, no contact.
Do you have anything at their house that you need to get?
At Jordan's, I do. I have money and I have clothing. That's it. I mean, I can.
Is that gonna cause a problem? Is Jordan gonna disagree that it's your money and your clothing?
No.
Okay. All right, ma'am, I'll release you, given your age and your lack of any prior criminal convictions. I'll release you to pretrial services. No contact with Alexis and Jordan. You can't go back to the incident location. You may return one time to the incident location with law enforcement to pick up any necessary belongings. You
Perfect.
must do monitoring or treatment as directed by pretrial services.
Okay.
Your court date's going to be on January 27th at 1:30 PM. I'll appoint the PD's office to represent you, ma'am.
Thank you so much,
Yeah, ma'am.
Your Honor. Thank you. Thank you so much. Yes. Thank you so much. You're awesome. Okay. Perfect. Thank you so much. George.
May I please, sir?
Robert George.
George, I'm seeing you on one count of burglary in the 3rd degree, one count of burglary, one count of possession of burglary tools. State's asking for a $5,000 bond. Given the warrant out of Santa Fe, I see a flight risk. Mr. Colesrud, my inclination was a $10,000 bond cash secured with in order not to return to the incident location. Do you want to be heard?
Good. Given Mr. George's circumstances, I'd ask that you impose a nominal bond. He is not in a position today to be able to afford his release. And so, that might change in the future. It looks like pretrial services was in touch with his family, who said that, like, his father, Robert, said that he could live with him and would take that third party custody of him. I understand the court's concern about the flight risk, the warrant. Though, as I understand it, Mr. George's circumstances are he was back in town to get an ID so that he could return ultimately to Santa Fe so that he could take care of that Santa Fe case. So the circumstances being what they are, I'd ask that if you're going to impose a monetary bond, you do so in amount such that, there's a risk to him if he doesn't show up for court, but is an amount that he might at some point in the future be able to afford.
George, you can speak, but talk to your attorney first.
Your Honor, the state has particular concerns because it would appear that this person went unseen and was allegedly trying to take tools. And that's particularly odious considering that's taking away somebody else's ability to make their living. It's not just taking their property, it's taking their financial security enabled in their ability to make a living. So the state stands by its $5,000 number.
Thank you, Neil. All right, Mr. George, do you want to be heard, Eric? All right. Counsel, my original inclination stands. $10,000 cash is secured. Court on January 20th at 1:30 PM. PD's office is appointed.
That was on the 20th, Judge?
Yes, yeah.
Myself, I'm already hurt. I'm already. I'm advising you that you should.
So, Mr. George, Mr. Colter is a good attorney. He knows what he's doing. There's nothing you can say that's going to change my mind right now, but what you say might end up doing damage to you. So you're free to speak. I can't stop you from speaking, sir, but that's my forewarning.
Well, Your Honor, what I want to go ahead and tell the court today is that right now in Israel and Hamas, they're fighting a war right now. And I have information that's detrimental to this matter because I know where the Holy Land is. There's a map on Wikipedia. And these people are dying over there. I'm not concerned about this case. I'm concerned about what's going on over there because I'm one of the children of Zion. I'm one of these children that have rights to this land here in America, in Utah is where the Holy Land is. And I can prove that to anybody and everybody. I want to let you know so that you can contact somebody and let them know that they need to start doing something about these people getting killed over here. These matters that are taking place today don't matter as much as other people's lives do. So really, that's all I can say. Forget this case. I mean, that's what's important to me.
All right, sir.
Rule 11, Your Honor.
I'll let his attorney advocate for him on that. All right, your excuse, sir.
Martinez Garcia.
Your name, please, sir.
Kenneth Martinez Garcia.
All right, sir. Sorry, I had two Martinez Garcias that I see here. Hold on. All right, sir. Mr. Martinez Garcia, is it Kenneth, sir? Is that correct?
Yes, Your Honor.
Sir, I'm seeing you on 2 counts of domestic violence, aggravated assault. State's asking for a $35,000 bond. Counsel, my inclination was a $10,000 bond, cash secured with no contact with the victims and not returned to the incident location. Do you want to be heard, Mr. Coulter?
I do, Your Honor. I'd ask that if the court's going to impose that monetary bond, you do so in an amount that Mr. Martinez Garcia might be actually eligible to afford here. He's working part-time, so he is employed. He does have housing separate and apart from the alleged victims and the alleged incident location. And it looks like pretrial services actually spoke to the folks who were alleged to be the victims in this case, which are his parents, and neither one objected to his release from custody. And it looks as though both of them welcome contact. So I would ask that if you were going to hold Mr. Martinez Garcia, that you do so on a bond that he might actually be able to afford given his employment and his financial circumstances. But then as it relates to the actual wishes of the folks who the state claims were victimized here, they don't object to his release. They're actually welcoming contact with him. It's his parents. I think under the circumstances here, Mr. Martinez Garcia doesn't have a history of violence that pretrial services has noted. And so for these reasons, Your Honor, I'm asking that, pretrial services doesn't know one. From what probation?
What kind of probation?
So given those circumstances, Judge, I ask that you impose, a minimal bond here. I'm hearing from the jail. I'm not seeing this in the PTS report, and it's not noted on the state's recommendation here that there's evidently a probation hold. And so, for those reasons, Judge, I'd ask that, while Mr. Martinez Garcia gets that cleared up, that he be held on a nominal bond in this new case.
Yeah, I didn't see the hold, but I do see that there's an allegation he's on probation. I also see an allegation that he has an active order of protection against him, although it lists different individuals than the alleged victims.
Your Honor?
Yeah, Neil.
CR 20, 24, 23, 27. He was convicted of theft or a lesser included on or about August of this past year.
Pull it up. Okay, let's see. Mr. Evans was your attorney. Mr. Martinez Garcia was a class 1 misdemeanor. You were placed on probation for 18 months on October 24.
Technically, unless he's been terminated, he's still on probation, Judge.
I don't know if there's going to be a probation hold or not. The jail says there is. I will remove the no contact order. I will lower the bond to 2,500 cash is secured, sir. So you may have contact with the alleged victims as they both want contact with you. For the time being, you cannot go back to the incident location. I understand that if you do post bond, there's somewhere else you can live. Your next court date is going to be on January 20th at 1 p.m. That's not going to go, sir. Talk to your public defender about that, all right? I'm appointing the PD's office to represent you, sir. Hey, jail, are we sure that probation has put a hold on Mr. Martinez Garcia? I want to make sure that there's the correct information in his
They showed the paperwork with the stamp. Yeah, it just doesn't look as though pretrial services was made aware of that, and I question that when it's a misdemeanor conviction and somebody's put on adult probation, but if they are asking for the hold, they're asking for the hold. Yeah. Yeah.
Good. All right. I'll mark APO hold. Mr. Martinez Garcia, you can advocate for your release at a future date with your attorney. So. Oh. You can.
Judge, is he excused?
He's excused. Sorry, Eric. Yeah, he's excused.
Yeah, I'm not. Yeah.
You can say your name, please, sir.
Jose Miranda?
All right, Mr. Miranda. Sir, I'm seeing you on one count of domestic violence stalking. State's asking for a $15,000 bond. The arresting officers were asking me to place a high bond on you. They stated specifically that you have harassed the victim constantly, even after you received an order of protection. They said that you told them that you cannot get over the victim and were likely to continue behavior if you're released. And there's word from the victim that she states she has fears for her life and her children's safety. My inclination, Mr. Colruyt, was actually to place a $50,000 cash secured bond with further orders not to contact the alleged victims, not to go to the victim's residence, workplace, or gym. Do you want to be heard, sir?
I do, Your Honor. I understand the court's position if you're going to impose a bond. The state's recommendation here at $15,000, I would think is high given the circumstances, and specifically Mr. Miranda's circumstances. Pretrial services notes that there's no prior history of violence, no prior felony convictions. I don't know about DV history. I'm not seeing anything here. The one thing I would note, Judge, is that on the complaint, I'm seeing several different dates. It says September 19th. Then there's a stamp with the offense time as November 3rd. And then the arrest was on the 6th. But then in the report itself, it says, this is from one date to the present, which is the 4th. So I'm not sure precisely when, I think the allegation is that there's a range here. But the circumstances being what they are, I don't know that a high bond is necessary to ensure that Mr. Miranda doesn't have further contact. Obviously, he would be under the court's orders to have no contact here, and certainly I think can understand what is going to happen to him if there are future issues, given his experience here being booked. So for these reasons, Judge, I'm asking that you impose, a $5,000 bond, cash is secured, so that he has the opportunity to afford his release and participate in his defense from within the community.
Miranda, I'm going to hold you on that $50,000 bond that I initially suggested. It's cash secured. You've already been ordered to have no contact with the alleged victim. That stands. If you do post bond, you may not go to her residence, her workplace, her gym, or any other place where she might frequent. Your next court date is January 20th at 1 p.m. I'm going to appoint the PD's office to represent you, sir, and you're excused.
Is that 50,000 or 15,000, Judge?
50, Mr. Coldren.
Understood.
Sit down, actually.
Your name, please, sir.
Rudy Miranda.
All right, Mr. Miranda, I'm seeing you on 1 count of possession of a dangerous drug for sale, 1 count of possession of a narcotic drug for sale, count of possession, one count of possession of narcotic drug, count of using electronic communication in a drug transaction, and possession of paraphernalia. State's asking for a $15,000 bond. My inclination was a $5,000 bond cash. Mr. Coulter, do you want to be heard?
Judge, I understand the circumstances here and the allegations. The thing I point out with the complaint here is that it seems like there's 2 people in this vehicle, and everything that the officers are putting down for the statement of probable cause are coming directly from the other person in the vehicle. And so, given the circumstances there, it doesn't appear as though the officers observed anything themselves. And the drugs, it looks like that they claim they found in this vehicle were in the driver's side, where they say that Mr. Miranda was on the passenger side of the vehicle. So there's some circumstances there that I think are going to warrant further investigation on the defensive side of things. And I think that Mr. Miranda's best bet at participating in his defense is if he's in the community. I'm asking that you impose a $1,000 bond, Judge, given those circumstances. That's a number that Mr. Miranda might actually be able to afford to secure his release and participate in his defense. And for what it's worth, Judge, he is employed, he is working. So, he would obviously not be idle and have something, to keep him busy in between court hearings here, and, continuing to contribute to our community in that form and fashion. Something that he obviously stands to lose if he's held in the Pima County Jail for an extended period of time.
All right, Mr. Miranda, I appreciate that. It looks like you haven't been in trouble since 2009. That's quite some time.
Yeah.
I don't know what's happening with this allegation. It looks
Right.
like you're the one who got caught holding the bag.
Yeah.
I'll reduce the bond to $2,500, cash or secured. Appoint the legal defender to represent you, sir. You'll have court on January 20th at 1:30 p.m. All right, sir, you're excused.
Other shed?
Your name, please, ma'am.
Melissa Mothershed.
All right, Ms. Mothershed, I've got you on a couple different matters here. I've got you on possession of a narcotic drug for sale, possession of a dangerous drug, possession of paraphernalia. I've also got you on 3 failure to appears for city court matters. State's asking for a $15,000 bond plus pretrial release. My initial inclination, counsel, was a $5,000 cash as secured bond. You want to be heard, Mr. Coulter?
Yes, Your Honor. I think given the circumstances here, the allegations are very, very small quantities. It doesn't look like anything, above 2 grams even, and very small quantities of like actual currency cash involved. I would imagine that maybe if circumstances were different, and had she been arrested on different charges, Elisa here might actually be looking at getting screened into steps because of the situation as it is. Because of the charges that she faces, she's not eligible for that. And so I'd ask, Judge, that you, if you're going to impose a monetary bond, that you do so something to the tune of $1,000 or $1,500, such that she, has the opportunity to secure her release and work with counsel in defending herself from within the community.
Ms. Mothershed, I would do that, but for the fact that you have 3 failure to appears out of city court cases, suggests a risk to flee to not appear at court. I'm going to hold you on that $5,000 cash secured bond. Set a court date of January 20th at 1:30 p.m. Appoint the LD to represent you. On your city court, ma'am, I'm actually going to release you only so that I can set a non-transport review hearing. That's going to be on February 13th at 9 a.m. I'm going to appoint the city PD to represent you on your city court matters. Without you there, ma'am, they'll advocate on your behalf without you being present. They will discuss with you what they've been able to do on those cases, ma'am. All right, you're excused.
Newbrock, you're next.
Oh, and enter pleas of not guilty on your behalf in the city court matters.
Get back to sign the bond. Gotta make legal calls to legal defense. Yeah, call.
Your name, please, sir.
Samuel Newbro.
Mr. Newbro, I've got you on an organized retail theft case on CR 2025-5828, a narcotic drug possession case, a paraphernalia case, and 7 city court failure to appear cases.
Yeah.
Give me 1 second, sir. State's asking that I hold you without bond, given the allegation that you were on release for the 2025-5828 case and got new possession charges. Because they're requesting that, sir, I need to set a no bond hearing for you. Your no bond hearing will be on January 12th at 1:30 p.m. You'll also have a preliminary hearing on January 20th at 1:30 p.m. I'm going to appoint the Pima County Public Defender's Office to represent you on these charges, sir. Give me 1 second, sir. All right. On the case that has been on the organized retail theft case, sir, I'm going to set a $500 cash or secured bond. You're getting time credit that way. on the organized retail theft charge, appoint the PD's office. You'll have an arraignment on this case on January 14th at 1:30 p.m. I also have you on a justice court case for a failure to appear for a shoplifting. I'm going to set a $100 bond on that case, cash secured. Again, you're getting time credit on all these cases this way. I'm going to appoint Alexander Ball to represent you on this case. You'll have court on January 8th. That's tomorrow with Judge with Judge Cornejo at 1 p.m. On the Marana City case, sir, I'll also hold you on a $100 cash secured bond. You'll have court today at noon. I'm going to appoint Hey, Eric, I'm going to change something here. I don't want him to have too many attorneys and too many court dates. So on the Miranda case, Mr. Newbrow, I'm going to appoint Janet Altschuler to represent you. I'm going to go back and change that. So for your JP court case, you'll also have Ms. Altschuler. What's the next event, Maria and Isa? I just have it on tomorrow. Is that an arraignment or is that a case management? It's a pretrial? All right, Sarah. So it says today at 12. For Miranda. Is it a pretrial? All right. So today at noon, you have a case management conference for Miranda City Court. Ms. Altschuler will be your attorney on that case. I'm also going to make Ms. Altschuler your attorney on your justice court case for shoplifting. So let me go back into the system, sir. Do you want me to?
So one thing, Judge, I've been looking here and I'm frankly a little confused. So the new case is a drug case that pretrial services notes he would be eligible for step screening. And then the warrant for the organized retail theft. I'm a little concerned by this here because it looks like I don't know if that case was pending or not. It looks like according to pretrial services, and I don't have a complaint for the organized retail theft matter, but it looks like that offense date was December 9th, 2023 is the allegation. But then the warrant only issued on that matter December 31st of 2025.
You might not have been on release.
That's right.
Neil, do you have any checking thoughts on that? Yeah, check on that because I certainly won't do a no bond hearing if he was not on release.
Right, and that he's, in the drug case, he's eligible for steps according to pretrial services. So if we could have that diverted to steps and rather than him being held, I think that's obviously in Mr. Newbrow's best interest.
Mr. Colder, I'm going to hold him. There's 5 different courts this time. I can hold him on a lower bond and let his next attorney advocate for why he should be released and what programs he might be able to get into that could help him with steps, but with 5 different courts to attend. And I think it's actually 9 FTAs now in 3 different courthouses. I'm going to place some bond on him.
Sure, and I understand that, specifically as it relates to the failures to appear in the misdemeanor cases. The issue is if he is held and then later indicted on the drug case, he can't be screened for steps. He's no longer eligible. It's pre-indictment diversion. And so if he's not held no bond and he's held, as you've held him here, $100 bonds in the two city court matters, he's going to be held. The issue is whether or not he's screened for steps is determined essentially today.
So I've been setting steps screening at the county attorney's behest. Even when I hold individuals, my understanding is they'll still keep the steps cases pending and potentially open while they deal with other charges. That was my,
Right.
that was right. So if I hold him on these bonds, this new charge that steps eligible doesn't necessarily evaporate. He may or may not be transported for that step screening. And of course, you know that another attorney can litigate and advocate for his release if maybe housing is concerned or treatment's a concern, or, you know, whatever the case may be.
Right. My worry here, Judge, is that he's not going to be screened for steps if it's not ordered here today at the initial appearance.
I was going to order it if, regardless, I'm sorry, Eric, I was going to order a step screening regardless of a no bond hold or a bond hold. I'll still order the screening.
Understood. So what would
I'm waiting for Neil to get back to us to let us know
Okay.
if we have actual information that he was released. I guess I could have looked that up as well while we were talking.
Judge, what I'm seeing here is he has several cases that are marked as open or in some, basically not, there are several cases that are indeed would be open. The first one I see, let's see, it's CR 2025-5828, which looking at that,
So yeah, he was never initialed on that case. He had an initial appearance in arraignment on December 31st that it looks like he missed, and Judge Monroe put a $500 bond out for him. So he was never.
if he was out of custody,
Oh, I'm sorry. Okay, I hear you.
he was brought into jail. He may have been released outright. And there's a difference, as we
He
all know,
wasn't.
between the IA and the arraignment.
He wasn't. It was a direct indictment, so he was never arrested on that and given conditions of release.
All right. In that case, Your Honor, based on the defendant's rather strong case, the state would recommend a $50,000 bond.
Right. Given the nature of all these charges, I'm going to do a $1,100 cash secured bond. None of these can be concurrent because they're all at different steps in different courthouses. So overall, I think 1,100, 500, 1,600 plus the other $200 bonds. So we're close to $2,000 in bonds right now. Steps screening will be on January 14th, sir. Do you know what the steps program is? We've been talking a lot and haven't asked you any questions. Do you know what that is?
No, I don't. I know.
All right. So the STEPS program is a program where if you do certain drug treatment classes, the Pima County Attorney's Office will dismiss the drug case against you as long as you do what the court asks you to do. Does that sound interesting to you?
It does.
All right. So I'm going to set a STEPS screening on January 14th. If the jail wakes you up to go to court on January 14th, actually, if the jail ever wakes you to go to court, just go.
Yeah.
I know it can be early in the morning. Just go to court. All right.
Well,
All right. So that does it for all but the city court case. On the city court case, sir, this is the only one I'm going to release you on. And that's because I'm going to set a non-transport review date in front of Judge Klotz on February 18th at 9:30 a.m. I'm going to appoint the city PD to represent you on that case. So you'll have the public defender, I think I said, on your felony case. You'll have the city defender on your city case. You'll have Janet Altschuler on your Miranda case and your justice court case. The city court case, sir, the city PD will talk to you about what they were able to do or not able to do regarding all your city court cases while you're pending your felonies. All right, sir?
Good.
All right, sir. That's a lot of information. take that piece of paper that Mr. Colesrud just filled out for you and hang on to it, all right, sir?
Thank you.
So you're excused.
Thank you, Judge.
Yeah, thank you. No, no, stay there.
Your name, please?
Miguel Peña, Miguel Angel Peña.
All right, Mr. Pena. I'm seeing on one count of aggravated DUI. State's asking for a $10,000 bond. My original inclination was a $15,000 bond, given the charges and given the previous DUI suspensions and orders.
That's fine with the state.
Mr. Colesrud, do you want to be heard?
Yes, Your Honor. So Mr. Peña has informed me he's got a family member in the hospital currently. He's concerned his family member is going to pass away. And Mr. Peña would like to, if the court would be inclined, have a lower bond imposed, something that he could afford so that he would be able to be there with his family, for his family, to be there for, I believe it was his grandfather, who evidently is soon to pass. And so things here to consider also is he's got a place to live. He's working full time. So, if he's incarcerated for an appreciable length of time, obviously he's going to lose that job. And I understand the allegations here. And this being an aggravated DUI, I'm sure the court is aware of, what often happens with ag DUIs. The county attorney's office very frequently will later dismiss, given the need for blood results. And they're not going to get blood results within 10 days before the preliminary hearing date. And so if Mr. Peña is held, there's a very substantial likelihood that within a week he would be released if and when this case is dismissed pending those blood results. And so we're asking, Judge, that if you're going to impose a bond, that you impose something that Mr. Peña could afford. And we're asking that you do so in the amount of $2,500, which would give him that opportunity to secure his release. Whether this case continues forward and he's indicted or it's dismissed and later refiled at a point later in this year, either way, Mr. Peña would like the opportunity to be there for his family. Thank you.
Your Honor, in the allegations, not only was he impaired, and apparently, based on what I can see here, there was indicia of some pretty severe impairment. He was on an expressway. He caused the accident, allegedly, and then allegedly fled. And I hesitate to use the phrase chutzpah, but for him to want a special consideration for the court because somebody's in the hospital is kind of ironic, considering he put somebody into the hospital with injuries because of his decisions.
All right.
$15,000.
Mr. Pena, I am occasionally dissatisfied by how the Pima County Attorney's Office prosecutes DUIs. I understand that Mr. Colesrud is correct that this case might be dismissed. That issue is not before me today. What's before me today is your conditions of release. I'm going to hold you on that $15,000 cash and secured bond, appoint the PD's office to represent you. I'm going to set a preliminary hearing date of January 20th at 1:30 p.m. That court date is unlikely to go, sir. Speak to your attorney about what that means and what the next 2 weeks look like, sir. All right, sir, you're excused.
Thank you, Judge.
Oh, these ones, look, there's multiple ones, or I just forget? Yeah. Thank you.
Emilio Pesina.
Your name, please, sir.
Emilio Piscina.
All right, Mr. Pacina. I'm putting you on 1 count of possession of a dangerous drug, 1 count of paraphernalia, and 1 count of ag DUI. State's asking for a $5,000 bond. My inclination before I saw that was a $5,000 bond, cash secured.
How do I have a possession charge?
The possession charge, sir, is based on their alleging you had 2.133 grams of methamphetamine near you. All right, Mr. Coles, my inclination was a $5,000 bond. Do you want to be heard?
Yes, Your Honor. I'd ask for a $1,000 bond if you're going to impose a monetary bond here. The wording in the complaint, I think, is interesting. I guess maybe would be the word I'd use. Because the broader circumstances here is that Mr. Pina or Piscina, I'm sorry, was driving another person actually to a rehab center. The one on Tanque Verde is for drug rehab, and that a person was in the vehicle being taken to a drug rehab place, and there was drugs found in the vehicle. I think it's difficult for the state to truly say here that those drugs were Mr. Piscina's or that they were his. And the thing that I think is really interesting is that the allegation is that they were found near him or in the vicinity, which is, I think, are artfully vague and can mean, either they were in the car and they were in the other person's pocket just sitting next to him, or in a backpack or what. I mean, it's hard to say based on what we've got in front of us with the complaint. So Mr. Piscina is employed. Obviously, I think, what we're talking about here is someone who's trying to do the right thing and get someone to a place that they need to go for their own benefit. And, for these reasons, Judge, I'm asking that you release Mr. Piscina either to pretrial services, or if you're going to impose a bond, you do so in a nominal amount that he could afford to secure his release and defend his case, because the allegations here, I think, are, like I said, interesting would be the word to use, and how this is described.
I don't disagree, Mr. Piscina. I have 4 prior felony convictions, though 1 prior misdemeanor DUI. I don't know if that's where you were bringing your girlfriend. I understand that's what you said. I don't know where the drugs were found. I understand they were found near you, according to the interim complaint. I've got some questions about it as well. Again, what's before me is your conditions of release. I'm going to do a $5,000 bond, cash is secured. Court date January 20th at 1:30 p.m. Counsel appointed as the PD's office, sir. And you're excused.
Thank you, Judge.
Put it down.
Your name, please, ma'am.
María de los Ángeles Preciado.
All right, Ms. Preciado, I'm seeing you on a warrant from Pima County Superior Court for 2 counts of possession of a narcotic drug, 1 count of possession for a dangerous drug, 1 count of possession of paraphernalia. Give me 1 second here to look at what pretrial services wrote. All right, ma'am. So it looks like we tried pretrial release before. That wasn't sufficient. I'm going to hold you on that $500 warrant amount that was referenced. Set a court date of January 20th at 1:30 p.m. and appoint the PD's office to represent you, ma'am.
Thank you.
Hey, actually, hold on, counsel. All right, hold on. The information is incorrect. You don't have a PH, you have an arraignment on January 14th at 1:30 p.m. All right, ma'am, you're excused.
Thank you.
All right, Eric, thanks to you and Neil. That was the longest fucking 20 defendants I've had yet.
Thanks to us, sir. It was the docket.
No, it was 20 people. I thought I'd be done by 9:30.
It's a marathon, not a sprint.
Have a good day, you guys.
Hey, you too.